In today's topic, we return again to this question of dispute resolution and how it is that businesses resolve disputes. And in this lecture, what we're going to be looking at is the public resolution of international disputes, meaning a resolution of disputes using public methods. Now, we know that disputes arise in business routinely, and resolution of those disputes is governed by the law. This is one of the things that the law does. The law does two things. It provides commandments or forbids things, and it provides a remedy in the case of that the right is ignored. And it does so by providing for a means of resolving disputes. Now, as we talked about in the last lecture, parties increasingly choose alternate forms of dispute resolution, specifically things like mediation and arbitration. Sometimes, however, the parties may not make that choice at the onset of the relationship. And if the parties don't choose an alternate dispute resolution method, then the parties must litigate the dispute. And I'll be using that word a lot, litigate, and the related word litigation. And essentially, when we talk about litigation, we're talking about resolving a conflict, a legal dispute, through the court system. That means filing a lawsuit, engaging in pretrial motions and discovery, eventually perhaps a trial, and then after the trial, an appeal. And so this area of the law is about litigation. So what we're going to do in this lecture is we're going to look at the procedure for resolving disputes, international disputes, in a court setting. Now, I should point out this is a very complicated area of the law, and this is a topic that if we were in law school, it would literally take an entire semester to cover. So I'm only going to hit the high points during this lecture. But you should, at the end of the day, have enough background now to know what is important for your business and for whatever attorney you retain to hear your dispute. So we start with a question: how do we resolve disputes through litigation? Well, litigation, this process of filing a lawsuit and going to court, differs throughout the world. You should know that in the business world, litigation is really the final alternative. It's the last choice. If you had a hierarchy of how to resolve disputes, ordinarily litigation would be at the bottom of that list. And so this is why I refer to it as the final alternative. If nothing else works, then we can use litigation to resolve the dispute. Now, in the United States, litigation as a means of dispute resolution is pretty common. It is less common elsewhere. And therefore, if you are involved in a dispute that winds up in litigation overseas, the people that you are engaging with and the court system that you are engaging with is probably going to have a lot less experience with this particular type of matter and this particular means of dispute resolution than a United States court would. In the United States, litigation has been for many years a primary means of dispute resolution, and therefore it remains very common. Now, one of the big differences in litigation in the United States, as opposed to pretty much the rest of the world, is that in the United States, the judge is meant to be neutral. The judge is there to keep the parties on an even playing field. Elsewhere, it's the judge who takes an active role in terms of investigating what occurred in the dispute, asking questions, taking evidence. So a judge in the rest of the world is going to take a much more active role than a judge in the United States. And again, this is an area of the law that you need to be aware of before these sort of things arise. Discovery process is another area where the law differs greatly depending on jurisdiction. The discovery process is that process whereby the parties exchange evidence and then use that evidence to build a case to be presented to the court. Now, in the United States, as we'll see, discovery is wide open, and it is very easily available, and courts will often require parties to produce things that they would otherwise not produce, whereas discovery in the rest of the world is more of a matter left up to the parties, in which each party assembles the evidence that it thinks is important for this particular case and submits it to the other side. And that's all that you get in discovery. Now, we mentioned this in the arbitration lecture as well. There are two issues that come up whenever litigation is involved. And in fact, these are the same exact issues that we saw when we were talking about arbitration. And that's the first question: where will the case be heard? What is the choice of forum? What court is going to hear the case? And secondly, what law will apply to the dispute? Whose law will apply to this particular dispute when the parties are from different countries? Now, as a general rule, I will tell you this: courts generally respect the choices that the parties make in their contract. And in your first writing assignment, you'll be on this issue. You'll be writing some actual contract language, and the reason why that language is so important is that courts will respect the language of the contract. And this is really true whether you are in the United States or elsewhere. The fact is, the courts understand the realities of the international marketplace, and they have recognized the importance of reducing uncertainty in international contracts. This is the thing, this uncertainty is the thing that bothers businesses the most when engaging in any sort of contractual transaction. And therefore, as a means of reducing uncertainty and thereby boosting commerce, courts have recognized the right of the parties to agree to matters before a dispute ever arises. So, first of all, choice of forum: where will the case be heard? The parties can choose where the case will be heard. It's called a forum selection clause, and it's something that you should be aware of, that we can decide in advance where the case is going to be heard. And the second element is the parties can choose what law will apply to the case. We can choose whose law. If this is a contract between a company based in Dallas, Texas, and a company based in Paris, France, the parties can agree beforehand that Texas law will apply to any dispute arising out of this transaction. So the parties can choose where the case will be heard, they can choose what law will apply, and the parties can choose what dispute resolution method is going to be used. A court will recognize and give effect to all of these agreements: where the case is going to be heard, what law is going to apply to the case, and what sort of dispute resolution method is going to be used. So if the parties agree to an arbitration, courts respect that and order the parties to an arbitration. If the parties don't agree to arbitration, if there's nothing in the contract that says arbitration, then the court will assume that litigation would be the preferred method. So what's important for you is to know that if there is a clause in a contract, whether it's a contract that your side drafted or the other side drafted, courts are going to give effect to that. So be very careful when executing a contract as to what is contained in the contract.